Hey everybody, I'm Mike. This is Budget Guns and Gear Reviews, and you are watching The Right of the People, where we use the first to defend the second every Friday night at 11:30 p.m. Eastern. So uncover your keyboards, fire up your fingers, and come join the conversation.
Hey everybody, I know it isn't Friday, it is in fact Wednesday. You are not having a stroke, a hallucination, a flashback, or whatever, but this is The Right of the People. It is Wednesday, April 29th, 2020, and we are here to use the first to defend the second. Reason I decided to go ahead and do this on a Wednesday at 7 p.m. instead of Friday at 11:30 p.m. Eastern is I'm not going to do show Friday. I'm going to get up and go meet a guy and go hunt some turkey and hopefully get a good video out of that on Saturday morning. So when I get home from work Friday night, I'm going to try to go to sleep. I generally don't wake up at 5:30 a.m. That's bedtime. So, this will be interesting. Speaking of interesting, we got some cool folks here on the channel tonight. We got Squibload, as always, his irascible yet lovable self. How you doing, sir? Bueller. Okay, well, we have Rich White in the house. How you doing, sir?
Yeah, not too bad. How's yourself?
I cannot complain, and if I did, nobody'd give a damn, right?
I don't know. I'm sure your wife would, maybe.
What's that?
I said, I'm sure your wife would, maybe.
Yeah, no. She'd tell me, shut up and go somewhere else if all I'm going to do is bitch.
Yeah. That's why they added the maybe on the end there.
Yeah. We have with us today the lovely Gunpowder Beauty. How are you, ma'am?
I'm doing good. Thank you for the invite.
You are most welcome. Always welcome here. Matter of fact, I think I'll just go ahead and put you on the regular list. I don't know why you aren't already there, but I figured, what the hell? Why not?
Aw, thank you.
Sure. Squib, are you there, sir? Have you come back to us?
You mean I walk away for 1 second, and that happens to be the 1 second that you call on me?
That's right, man.
Yeah, what's up?
Same old, brother. It's I was about to say it's a Friday night, but no, it's not. It's a Wednesday afternoon, Wednesday evening.
But it feels like Friday.
Yeah. Hey, Calaveras 32 Special is asking for a link out there. You should have one in your email, sir. I believe I sent you one. So check your email, brother. Speaking of out there in the chat, we got, wow, old Sourpuss Pickle was out there early, man. Awesome. And we got Chris Fulmer out there. Midnight Range TM said he did not authorize this. I know, I am a rebel today. Gunpowder Beauty pulling double duty. Hey, I'm a poet and didn't know it. Rich White's out there as well. The aforementioned Calaveras 32 Special. Vintage Swiss. That's a new one on me. Welcome to the chat. Welcome to the show. Hopefully you stick around, be part of the conversation, because that's something I really love about this platform versus like TV or radio or anything else like that, is that's all only one-way flow of information. That's listening to somebody lecture and bloviate. Instead, you get to listen to me lecture and bloviate, and you can respond. So please, sound off out there in the chat if you haven't already, folks, so that I can say hello to you and, respond, and you can be part of the conversation too. Who else? Mad Sexy's in the house. We got Grim90. DTemp62, how you doing? DM Foss. And I think I've caught up. Oh, Pickle did not get a link. Well, let me fix that. All right, quick. I will shoot you a good old link-a-rooney. And sorry for the silence, folks, but there has to be some sort of technical difficulty or it isn't my show, right? So there you go. You should have a link inbound, Pickle. Let's see who else is out there. Drucifer has joined us. How you doing, sir? So, why am I here tonight other than watch you let you watch me send Pickle a link? Well, we got skullduggery and what some would call treachery afoot. Damn it. None of it's good. All of it's horrible. No, not all of it's horrible. There's some good stuff tonight, but not a lot. Pickle, how you doing, sir?
Doing all right. Just got off work.
Oh, that's always good. Now, see, why?
Yeah, that's for. You know what? Had a short day today, only 8 hours. That's for which is a drastic improvement to the 16-hour day that I worked on Monday.
Well, yeah, it's always good when you don't have to work the double, right?
Yeah, that's for, Saturday was a 12-hour, Sunday was a 13, and Monday was a 15. So it's been a good week.
Ugh. Looks good on the paycheck, though, don't it?
Except when your salary.
Well, yeah, that usually does suck.
Pickle, next time negotiate.
Yeah, that's right. I think I'm going to get about an extra 4 hours of overtime on this check, above my 40. So at least I get a little bit.
Well, that's good.
Anyhow, that's for enough of my complaining.
Yeah, I used to have what they call a flex schedule. It means it didn't matter when I was there as long as I was there 80 hours in a pay week. But on the other hand, I could get no overtime ever. If I did have to work over, say I had to work a 16 for some reason, then I had to pick one of the other days to flex it out. And that kind of sucked. I mean, it was free. It was good on one hand because it didn't matter when I was there, as long as I was there when I needed to be, if that makes any sense. But yeah. Now I'm on a straight 40 hours a week, and I actually prefer that. I can't handle the freedom.
Yeah, that's where we don't. I guess you could describe ours as flex, being that we're not told you punch in at this time, you punch out at that time. It's we have projects, we have deadlines, and we only have X amount of money for a project. Get it done.
Yep. Sounds right. So, but not getting overtime sucks. And speaking of things that suck, you guys are getting hit pretty hard, man. Last week we talked about how Judge Benitez issued a injunction against the California ammunition background check law. Well, the Ninth Circuit jerked that right out from under you guys, just like they did the magazine ban. This is
that's for the. Sorry, go ahead.
No, go ahead.
The our Attorney General had the stone. That's where the ruling came out from Becerra. About 5 o'clock on Thursday afternoon. Becerra had the stones on him to go in Friday morning and flat out tell Benitez, give me a stay on the decision or I'm going to the ninth. So when Benitez did not, refused, he went, Becerra went to the ninth, and at 9:54 p.m., a judge of the Ninth Circuit Court issued the stay.
Yep.
When was the last time we saw a judge working at that late on a Friday, and when was the last time we saw a judge respond that quickly?
Well, last week, apparently. This is a piece from the Washington Free Beacon. Appeals Court reinstates California ammo ban. This is by Stephen Gutowski from April 27th, 2020. The California law mandating background checks for ammunition sales is back on, despite a judge's warning that the law is unconstitutional. The Ninth Circuit Court of Appeals issued an emergency stay reinstating the law on Friday night, just 1 day after a federal judge declared that the law violated the Second Amendment. Under the ruling, California residents are once again barred from purchasing firearms and ammunition across state lines or without a background check until the case is decided. Chuck Michel, president and general counsel for the California Rifle and Pistol Association, which brought the suit, said he is confident that the appeals court will strike down the law after a full review. The state wants to block the district court's order allowing ammunition to be sold as it had been for 100 years at the exact same time the value of a firearm as a self-defense tool is even more realized given these uncertain times, Michel told the Washington Free Beacon. We expect to be back in court this week to show that the state's failed scare tactics are just as invalid now as they were when the district court rejected them in the past. The Office of California Attorney General Javier Becerra, Democrat, did not immediately respond to a request for comment. Judge Roger Benitez ruled on Thursday that California's new ammunition background check law misfires and the Second Amendment rights of California citizens have been gravely injured. He called the law, which passed in a 2016 ballot initiative, onerous and convoluted, pointing to the 16.4% false positive rate in the background checks on ammunition sales. Law-abiding citizens are imbued with the unalienable right to keep and bear firearms, along with the ammunition to make their firearms work, he wrote. That a majority today may wish it were otherwise does not change the constitutional right. It never has. The Ninth Circuit granted a stay pending further court order, but did not offer further explanation. The court date has yet to be set for the next proceeding in the case. So, wow,
that's
man.
Right. On the part where it says until the case is completed, from what an interview I was hearing with, one of the heads of Gun Owners of California, which is our local branch of the GOA, they're saying there will be a 3-judge panel that, every month there's a new panel convened to examine, emergency stays, and they can either decide to uphold that and it will continue for the duration of the case, or they can actually toss that stay out and we can go back to buying ammo normally, while the case, while this is in the court. So we'll have to see how it goes.
I would hope that's how it does go. There's a piece that from well, first off, before I move on to the next part of this, does anybody have anything to say? Anything to add to this? Any comment to make? Any observations? Any suppositions? Anything?
Yeah, I'm wondering if what's his face out there, the Attorney General's buddies with the judge that made that decision, and he just caught him at home and had him sign the stay there, because that's been known to happen before too, where a judge doesn't even have to be in their office to order a stay. They can do that right from their home.
Yeah, especially at 10 o'clock at night.
Yeah, that smells rotten to me. David
Yeah,
Ramirez out in the chat
where-
says he was able to place an order for 500 rounds of 223 for his Freedom Day. And then Mad Sexy says it wasn't even a day. It was that same night.
Yeah, that's where a lot of people didn't find out about it until Friday. So that's where they didn't, get their orders in Thursday. I ordered 1,000 rounds of 5.56 on Thursday. So that's where some of the retailers were, if the ammo hadn't actually gotten to you yet, they were rescinding orders and refunding, pulling something similar to what Cheaper Than Dirt had done back in the day.
Yeah.
Other ones, like, Ammunition Depot was an example, because they were one of the first ones to, to start selling to California, because they were, I don't know if they were a plaintiff or they were helping fund the case or whatnot, so they knew about it immediately. That's where I was able to order from them, and when the stay came out Friday, they issued a notice on their website saying any ammo that was already on the trucks out the door, would go to their, whoever purchased it. But any ammo that hadn't, completed, the transaction and landed on the trucks yet would have to be canceled.
David says he got his order in on Thursday from Classic. Good for you, man. Glad you got it. So, that's DTemp 62 rightly points out that the Ninth Circuit is the most overturned court in the land. So, what's next? We already talked a little bit about that, but let's see what Dave Workman from Liberty Park Press has to say about this on April 27th. California ammo check victory short-lived. What happens next? A stay against a federal district court ruling that struck down California's background check requirement for ammunition purchases could be challenged as soon as today, according to attorney Chuck Michel, lead counsel in the case of Road v. Becerra. Last Thursday, U.S. District Court Judge Roger Benitez ruled the state's ammunition check requirement violates the Second Amendment. The state moved quickly, initially asking the judge for a stay pending an appeal, but Judge Benitez denied that motion Friday afternoon. Attorney General Javier Becerra then raced to the Ninth Circuit Court of Appeals in San Francisco, which late Friday evening did grant the state's emergency motion for a stay, pending further court order, as noted in a timeline of the case posted online by the National Rifle Association. Michel told Liberty Park Press he expected to be filing a motion to vacate the Ninth Circuit's administrative stay and oppose the state's request for an emergency stay. Those actions could come quickly. All of this comes as part of a larger legal war suddenly being fought on several fronts. The Second Amendment Foundation, Firearms Policy Coalition, and National Rifle Association have all been busy since the onset of the COVID-19 outbreak, battling administrative shutdowns of firearms retail businesses as non-essential in several jurisdictions. At a higher level, SAF now has submitted 4 gun rights cases to the U.S. Supreme Court for review, which apparently is not lost on Associate Justice Brett Kavanaugh, weighing in on the court's decision to moot the challenge of a now-defunct law in New York City that prohibited handgun owners from taking their licensed handguns outside of the city, even to secondary residences. And we will be talking about that those events here very shortly. That's next on my agenda tonight. So try not to jump on that one quite yet. While he concurs with the court majority to moot the case brought by the New York State Rifle and Pistol Association, Justice Kavanaugh acknowledged the frustration of fellow Associate Justice Samuel Alito that state and lower federal courts are not properly applying the Heller and McDonald rulings when deciding gun rights cases. The court should address that issue soon, Kavanaugh wrote, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending before the court. The 4 SAF cases to which Kavanaugh was apparently alluding are Rodriguez v. City of San Jose, Pena v. Sid, Culp v. Madigan, and Mance v. Barr. The Mance case involves SAF's sister organization, the Citizens Committee for the Right to Keep and Bear Arms, as a plaintiff. Justice Alito presented a spirited dissent spanning 31 pages in which he dissected the city's now former law and the reasoning behind it is weak. We'll go into that a little bit more here in the next one. I guess that will be a good segue. So, your assertion, Pickle, that this ain't over till it's over is absolutely correct, because it's still going to be fought, the whole ammunition background check thing. This is just a temporary setback, I suspect. But it's really going to depend on who those 3 judges on the 3-judge panel of the Ninth Circuit are going to be. And then if... whichever way that goes down, I'm sure whoever they decide against will request an en banc panel hearing of the Ninth, and then it'll really depend on who those judges are. That's what I think about it. What about you guys?
Yeah, I agree. I said that last night on whose show was it? Was it on Sand Hill show when we were talking about it? I brought that up, that what's going to happen is you then have to go to the, basically, like you said, do an en banc hearing, and hopefully then the full night, well, not the full, but the full panel, was it 9 on it, that they have to have assembled for an appeal. Some of the judges that Trump's appointed, maybe then they'll get that overturned, and when it goes to en banc, and then I'm sure the state will appeal it, which then it'll go to the Supreme Court, just like everything else.
Yeah. And then who knows what'll happen at that point, how many, if they decide to take it to SCOTUS, how long that'll take to even be heard. Although, there is kind of some movement on that front with SCOTUS. I guess we'll go ahead and move into that as soon as I switch my topics around.
Yeah, that's for the the magazine ban was, before you completely changed topic. That's for Rich just got in there before I did. That's for the en banc will be probably called for the ammo regardless of who wins. Just like I believe the magazine thing will as well once we finish the 3-judge panel, which they've already had oral arguments for. And as my understanding, the state's assault weapons ban case is also on Judge Benitez's desk. But depending on if SCOTUS takes up, because as I understand, I think you're going to get to this in a little bit, but they have a few more that they can potentially choose from.
Correct.
And one of those is national assault weapons law. So if they take that up, he may not rule on California's.
Yeah, because that might be rendered moot by the federal case. Speaking of rendered moot, we've been talking about for quite some time the New York State Rifle and Pistol Association versus New York City case. For those who don't know what that is, that's where the New York City said that you couldn't take your firearm outside city limits. You couldn't take it anywhere in the city except for one of 7 ranges in New York, and that was it. Even if you have 2 residences in the city, can't do it. If you have a residence in the city and a residence outside the city, can't do it. Can't legally take your guns from one to the other. Can only go to the range and back, and that's it. Well, they got sued. And it ended up getting bumped to the Supreme Court. And when the Supreme Court granted cert to the case and said they would take it, New York City changed the law. And, This is from gunsamerica.org. Supreme Court dismisses New York handgun case. From April 27th. In a widely anticipated ruling on Monday, the Supreme Court dismissed New York State Rifle and Pistol Association, Inc. versus City of New York, a major gun rights case challenging a now repealed New York City law that banned transporting handguns to shooting ranges and second homes outside the city limits. In an unsigned opinion that appeared to split 6-3, the court declined to rule on the merits of the case, stating the challenge is now moot because New York City has since repealed that law. But all 4 conservative justices signaled the court may take up another gun rights case soon. The case was initially filed back in 2013 by an NRA-affiliated gun rights group and 3 New York State residents who are licensed gun owners. They argued the law violated their Second Amendment rights, which had been affirmed by the landmark 2008 Supreme Court case District of Columbia v. Heller and the 2010 decision in McDonald v. City of Chicago. These decisions established a constitutionally protected individual right to gun ownership. I would say the Second Amendment established that, but yeah. New York City argued that its law was essential to protecting public safety. The case made its way up to the Supreme Court, which decided in 2019 to hear it. But before the court could hear arguments, New York City and New York State amended their laws in June 2019 to remove the ban on transporting handguns to shooting ranges and second homes. The state also passed a law that would keep bans like that from being reenacted. This set the stage for a mootness hearing in December 2019, and the court allowed the case to move forward. In the unsigned opinion on Monday, the justices ruled the NYSRPA's challenge was moot because the city's law no longer prevents licensed gun owners from bringing their guns to shooting ranges and second homes outside the city. The court wrote that this is the precise relief the petitioners requested and declined to rule on the merits. The gun owners had added to their challenges that even if the new law allowed them to transport their guns outside New York City, it didn't allow for stops along the way, i.e., to get gas or use the restroom. The Supreme Court also declined to rule on the merits of that challenge. The justices also made no ruling in a claim for damages under the old law, remanding the case back to the lower courts. Justice Brett Kavanaugh concurred with the majority opinion that the case before the court was now moot. However, he expressed concern that the lower courts may not be properly applying Heller and McDonald in deciding Second Amendment cases. Writing in a 31-page dissent, Justice Samuel Alito was critical of the majority opinion, arguing that the dismissal for mootness wasn't correct and that the decision permits our docket to be manipulated in a way that should not be countenanced. Alito wrote that even though New York City changed its laws, the changes do not go far enough because they don't give unrestricted access to shooting ranges, competitions, and second homes, which was desired by these gun owners. Justices Neil Gorsuch and Clarence Thomas joined Alito. So what happens next? The case now returns to the lower courts, which will consider whether there is any merit to the newer claims brought by NYSRPA, including whether damages should be awarded related to the old New York City law. In the meantime, there does seem to be a strong likelihood the Supreme Court will take up another gun rights case in the next term. A key question for the court is whether the individual right to keep and bear arms affirmed in Heller and McDonald applies outside of the home. At the end of Kavanaugh's concurrence, he writes that the court should address that issue soon, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending before the court. SCOTUS blog appears to agree, and the major court watcher tweeted Monday morning, the opinions in today's NYC gun rights case strongly suggest that there are at least 4 votes to consider another Second Amendment dispute very, very soon. So, SCOTUS mooted it. It goes back to the lower courts, who then decide on the strength of the new challenges that were brought up.
Can I say that, with, Kavanaugh making these claims of that he feels this and feels that, but the way he voted, to me, it sounds like lip service. Like he's trying to make people think he's pro when he may or may not be. We're still yet to see.
Maybe. Does anybody else have an opinion on this? Before I go into the next one and see what and then give my opinion.
Yeah, I'm not necessarily saying that I agree with the decision, but I also can see their point on the mootness of it. You can't challenge a law that doesn't exist anymore from a logical perspective. So I can see why they would rule that it's a moot point right now. But I'm not saying I agree with that decision, but I can see logically where they're coming from with that decision. At least this one has some logic behind their decision, where a lot of times they make a decision, you're left scratching your head. Why the hell did they rule that way? This one, at least there's a logic behind it, if you know what I mean.
Enrique Sonora says he wishes the lower courts to set precedent so that he doesn't have to write or commit to anything. Yeah, Kavanaugh does seem very reluctant to set precedent. He needs to realize that he's on the court now that does set precedent, the ultimate precedent, as far as legally speaking goes, and he should act like it. But all hope is not lost here, because as I've said before, I do still believe that this battle will be won in the courts. It just is going to take the right case. And I suspect that that may just be what SCOTUS is waiting for, is the right case. As Rich said, it's kind of hard to rule against a law that doesn't exist anymore. Now, I don't think they should have allowed that to happen. I think they should have ruled on it anyway, just to prevent local governments from doing this very thing. If something that comes before SCOTUS and they think they're going to lose, well, let's just change the law and do an end run around it. And I think that's crap. I think that is something that the court should not have allowed. I agree with Justice Alito on that. They should never have allowed it to happen. But they did. Why? I mean, maybe from a strict legal sense, it makes sense. Well, kind of. Maybe they want to take a more concrete case. I don't know. But there are some more cases that they have to choose from. And that's the good part here. That's the hope of what... maybe they have something that they can apply in a more broad fashion. This is from Reason.com. After NYS Rifle and Pistol is dismissed, SCOTUS distributes 10 Second Amendment cases for 5/1/2020 conference. So they're looking at 10 Second Amendment cases here, folks. Maybe they feel one of those would be a better, more of a home run. I don't know. That's just me trying to be positive with this. This is by Josh Blackman from the Volok Conspiracy. On Monday, the Supreme Court decided NY State Rifle and Pistol Association. Let me know if you'd like an edited copy. 4 justices signaled they were ready to take another Second Amendment case. Justice Kavanaugh wrote in his concurrence, "And I share Justice Alito's concern that some federal and state courts may not be properly applying Heller and McDonald. The court should address that issue soon, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending before the court." Justice Alito wrote in his dissent, joined by Justices Thomas and Gorsuch, "We are told that the mode of review in this case is representative of the way Heller has been treated in the lower courts. If that is true, there is cause for concern." Immediately after the case was decided, the Supreme Court distributed 6 Second Amendment cases for the May 1st, 2020 conference. Mance v. Barr from the Fifth Circuit, challenge to the federal prohibition on out-of-state handgun purchases. Pena v. Horan, Ninth Circuit, challenge to California's prohibition on unsafe handguns, including the microstamping requirement. Gould v. Lipson from the First Circuit, challenge to Massachusetts may issue concealed carry licensing regime. Rogers v. Gruel, Third Circuit, challenge to New Jersey's may issue concealed carry licensing regime. Cheeseman v. Polillo, New Jersey Supreme Court, challenge to New Jersey's may issue concealed carry licensing regime. Ciolek v. New Jersey, from the New Jersey Supreme Court, challenge to New Jersey's may issue concealed carry licensing regime. Mance v. Barr is the oldest case on the list. My colleague, Alan Gura, filed this petition in November 2018. It was originally distributed for the 3/29/19 conference, but then was rescheduled. The petition was then distributed at the 4/12/19 conference. Yesterday, the court scheduled the next distribution for 5/1/2020. This petition is an excellent vehicle if the court wants a law-profile case that won't reach any sweeping rulings. I wonder if he meant low-profile. Or, if the court wants to take a concealed carry case, Rogers v. Gruel has been floating around since December 2018. The 2 criminal prosecution cases can be held over and vacated if Roger prevails. Once the court decides one or more of these cases and clarifies the appropriate level of scrutiny, the other cases can be GVR'd. Update! SCOTUS blog located 4 more Second Amendment cases that were distributed for the 5/1/20 conference. Werman v. Healy from the First Circuit, challenge to the Massachusetts ban on assault weapons in large-capacity magazines. Malpaso v. Palazzi, Fourth Circuit, challenge to Maryland's may issue concealed carry license regime. Culp v. Raoul, Seventh Circuit, challenge to Illinois' ban on allowing non-residents to apply for concealed carry license. And Wilson v. Cook County, Seventh Circuit, challenge to Cook County's ban on assault weapons in large-capacity magazines. We should know Monday morning whether there is a new grant, and invariably, the local governments will try to moot the cases. Again. So there is some hope here. There are 10 cases right now being discussed by the Supreme Court that they might decide to grant cert to in here. Maybe one of them is the case they're looking for. What do you guys think? Is that, or is that a realistic thought, or am I just hoping?
With all those concealed carry permit cases, I could see them adjoining all those cases together into one case and hearing that one for sure. Because you got umpteen challenges. What was it? 3 from New Jersey alone?
Yeah.
And then 1 from Maryland, and you said another state. I don't remember which one it was. That's at least 5 concealed carry cases right there.
And really, they wouldn't have to combine the cases. They could just rule on one, and it would affect all of them.
Yeah. Oh, yeah, that's true too.
Yeah, depending on how narrowly or how broadly they rule. But that the fact that they have agreed to conference on 10 cases, a rule of averages says there's a pretty good chance that they're going to look deeper into at least one.
I hope so. I really, really hope so. Speaking of hope, Seven Wonder says, I hope Kavanaugh shows that he's actually pro 2A. Yeah, that would be nice, right? Mad Sexy says, well, I hope they all do.
The benefit, if they were to join them, would be that they would get the extra testimony from all the organizations involved. Because you would have the New Jersey gun rights people, the Maryland gun rights people, and wherever the other state was, their gun rights people all testifying as well. Whereas otherwise, if they don't join them, you only get one of the state's organizations testifying.
Well, they could file amicus briefs. The rest of them could. David Ramirez says, I need that California gun roster ban overturned. There's so many pew-pews I want to buy. I hear you.
The problem with the amicus brief is they only got so much time before.
Yeah.
So, I mean, there's like you were saying, there's multiple different ways they could do it. But,
and then there's the cost.
Joining those cases might be the best way. But
and then there's the cost of even filing an amicus brief. Did you hear?
Oh, yeah.
Were you watching Ghost's chat with Joshua Prince?
Yeah, I caught part of it.
20 G's just for the printing.
Yeah.
It's ridiculous.
And you got to have it written just right, or they won't even look at it.
I think they do that to keep access to the courts out of the common folks' hands. I really do. That's just horrible.
Yeah, another reason why them joining the cases might be the best bet. It'll save everybody some money and a headache on having to write those papers just right. Because if you don't use the right font, they're not even going to look at it.
I know, that's stupid.
I have to ask, why the hell do they have to, do they need their own special, friggin' format, font, and everything else, for something like that? That's just,
Yeah, it makes no sense to me.
Bureaucratic waste.
It makes no sense to me. As I said, I think it's just a stumbling block. It's a hurdle. That's all it is.
Yeah. It's one of those technicalities that you see people getting off on crimes for. Oh, this paperwork wasn't filed properly. We got to dismiss the entire case. Same basic thing.
Yep. Outdoor Avenger says, hello from Ohio. Trump 2020 all the way. Well, hello back at you, still from Ohio. Welcome to the show. Hopefully you stick around, be part of the chat. If you have something to say, make sure you say it. I as I said earlier, I love to have the engagement with you guys. That's what I like about this format right here. Enrique Sonora says states are going to have to do the same as AZ. Local government can't rule out state law. You know what? There are a lot of states that have preemption laws like that, including Mississippi. But you know what? Tyrant's going to do what Tyrant's going to do. That's that. Unless and until they are stopped. As an illustration of that, this is from guns.com. Mississippi, citing COVID-19, Jackson mayor bans open carry. From 4/27/20. Democratic mayor, and I'm sorry, I'm going to butcher this name, but I'll do my best. Mayor Chokwe Antar Lumumba, over the weekend, announced he has suspended legal open carry in Jackson, Mississippi by executive order. In a video released by the city on Saturday, Lumumba cited the city's current state of emergency in response to the COVID-19 outbreak, saying he was granted powers under state law that allowed the move. The open carry law not only provides protection to individuals who are armed with illegal weapons, it creates an atmosphere of fear and intimidation in the community, said Lumumba. We cannot continue to turn a blind eye to the fact that the open carry law has led to an increase in gun violence into our communities. I'm sure that the entirety of that statement is a freaking lie. Mississippi adopted a popular open carry law in 2013, followed by constitutional carry measures in 2015 and 2016. Further, the Magnolia State has strict preemption laws against local firearm regulations which allow for significant penalties for city and county public officials who violate the statute, including a personal fine of up to $1,000. Other state laws forbid cities from regulating otherwise legal carry of firearms in times of declared emergency. In response to the news from Jackson, Mississippi Attorney General Lynn Fitch on Sunday said cities can't usurp the authority of the state's elected legislature and violate the constitutional rights of the people. I support the Second Amendment and will enforce the laws of the state. Lumumba has supported Everytown-backed initiatives in the past, including declaring June 2nd Gun Violence Prevention Day in Jackson just months after he took office. So far this year, the first-term Democrat has held high-profile events with former New York Mayor Michael Bloomberg, last month endorsed Bernie Sanders for president, and 2 years ago said he wanted to turn Jackson into the most radical city on the planet. Meanwhile, Moms Demand Action has described Lumumba's move to avoid open carry in the state's largest city a, quote, wise decision, unquote. So, yeah, Tyrant's going to do what Tyrant's going to do, and the law be damned.
That's where I want to say there's the state attorney general of Mississippi even warned that mayor that you can't do that. You might want to back off on it. So that they might want to take heed.
Well, shit, I missed. Well, there's a development in the case. Again, from guns.com, this is from today at 2:42 a.m. by Chris Egger. Jackson mayor hit with lawsuit, spurned by city council over open carry ban. Just days after Jackson Mayor Chokwe Antar Lumumba, Democrat, moved to outlaw legal open carry in Mississippi's largest city, he's finding little support. On Tuesday, the nonprofit Mississippi Justice Institute filed a lawsuit against Lumumba on behalf of State Representative Dana Criswell, Republican. The 13-page filing in U.S. District Court holds that the mayor does not have the authority to override rights protected by both the U.S. and Mississippi Constitution, even during a state of emergency. As a citizen of the great state of Mississippi who has regular business in our capital city of Jackson, I was shocked by the recent announcement by Mayor Lumumba, said Criswell in a statement. I take the protection of myself and my family very seriously and believe deeply in the constitutional right to keep and bear arms. The mayor's attempt to disarm me and deny me the ability of self-defense puts me and my family in danger anytime we are in Jackson. State Attorney General warns. Other legal action could be on the horizon for Lumumba, a progressive who previously pledged to turn Jackson into the most radical city on the planet. Mississippi Attorney General Lynn Fitch on Sunday rebuffed the mayor in a 2-page letter in which she explained that he did not have the power to bar open carry in the city. Mississippians enjoy the right to lawfully open carry in all of Mississippi's 82 counties and in every municipality within the state, said Fitch, a Republican. The city of Jackson is no exception. The city lacks statutory authority to suspend a state statute or constitutional provision. Accordingly, I ask that you rescind the order immediately. I take seriously my obligation to protect Mississippians' constitutional rights, and I will take every action available in my office to ensure these rights are not infringed upon. Good for you! Fitch's letter was echoed and supported by national gun rights organizations, including the National Rifle Association. City Council refuses to support. Jackson's Democrat-controlled City Council voted unanimously on Tuesday in favor of a resolution opposing a ban on open carry in the city, as reported by the Clarion Ledger. The lawmakers stressed that they were not consulted on the ban beforehand and are disinclined to enter into what is shaping up to be a wave of litigation. I'm in favor of anything we need to do to lower crime in Jackson, but this is a legal issue for the city, said Ward 6 Councilman Aaron Banks. So far, the only supporters for the ban outside of Lumumba's office seem to be anti-gun groups, with the state's Moms Demand Action chapter calling it a wise decision. An online petition launched by Lumumba over the weekend to stump for a statewide ban on open carry had just 110 signatures as of Wednesday morning. It is not known how many of those, if any, are registered voters in the Magnolia State. Good. I hope this jackass gets tons of backlash from this. I hope he gets sued into the poorhouse. And as a matter of fact, I hope they clap his ass in irons and stick him in the jailhouse, which is what should happen to a tyrant.
Yeah, it's certainly the nicer of the options, of what could happen to tyrants.
Yeah, I said this last night on Sandhill's show, and I'll say it again here. I think this guy let his name go to his head, and he thinks he's an African dictator.
Yep. No, Midnight, I did not say I'm engaged to a dude in the chat. I said I love the engagement of the chat. Get the pancake batter out your ears, dude. I know you work at IHOP, but still. Let's see. 7 says that's ridiculous. Total BS. Idiot. Midnight says, yeah, he's named after one of those little carpet cleaning robots. D-Temp says, la 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 bamba. Let's see. DM Foss says Lumumba was backed by Bloomberg. Doesn't shock me. Bloomberg has said before that his money comes with strings. Time to pay up, sucker. Andrew Faulkner wants to know why we're talking about his Roomba. It's just sitting on the dock charging. D-Temp says, I wonder if he's now a last-term Democrat. I hope so. Enrique Sonora says the 2A movement is going to have to look at these types of countermeasures and pass legislation that forbids this type of executive orders. Absolutely right. And they should have teeth involved with them, not just bad, don't do it again. They need to have a $1,000 fine, nothing. 10,000, 15,000, 20, 50. That's the kind of fines that they need.
But then you also have to have some, having a law with teeth only helps if you have someone with the stones to enforce it. Because there has been plenty of laws passed over the years to limit what government can do with penalties that the government has violated and then no one's gone after them for. So,
well, apparently this state's attorney general is going to do her job. That's awesome.
About time some government work.
What's that?
It's about time, one of those high-level government workers does their job.
Yeah. Absolutely right. Let me see. Where am I at? Sean Callahan said Jackson's such a crap hole it made Charlie Daniels head to L.A. via Omaha. Now, boys, be nice out there. Hi, Vanessa Kitty. Glad to see ya. I know I've been doing it a lot later lately, and, I can't, don't have you out there in the chat anymore. I missed seeing your name. Good to see you here today. Vanessa Kitty says they need felony level punishments. Make it criminal. Absolutely right. So, tyranny is on the march all across the fruited plain. That's wonderful. There is a little bit of hope with these potential cases before the Supreme Court. I hope that it results in a slam dunk Pro 2A ruling on one of them. If I had to bet, I think it'll probably be one of the concealed carry cases that they have, because they have a bunch of them from different circuits. They're going to want to rule on that issue, particularly since, the lower courts are trying to weasel out of Heller and McDonald applying outside of the home. So I think and given that was the language that was used in Alito's dissent and even Kavanaugh's concurrence, that it's one of those cases that they'll grant cert to, if any. But you never know. The law is full of strange things. And here's one last bit of strangeness that might be worth looking into and thinking about and getting some more information on. This is from a guy named Clayton Kramer's blog. This is from Friday, April 24th, titled Hard to Believe. Said, a prosecution for unlawful machine gun possession was granted cert by the Supreme Court, and the Justice Department filed a motion applying to vacate the judgment and drop the indictment. It appears that the defendant challenged the constitutionality of the indictment before this went to trial. The argument that scared the DOJ into dropping felony charges is this: the federal authority to regulate machine guns is derived from their authority to tax them. Since 1986, it has been unlawful to make them for private ownership. If they will not collect that tax, do they have the authority to regulate their possession? Apparently, this is a side effect of ACA, which required you to pay a tax for not being insured. The penalty was reduced to 0 recently by Congress, so the individual mandate no longer has any basis because it was derived from congressional taxing authority. It appears that DOJ has figured what my friend Stephen Halberg argued in U.S. v. Rock Island Armory could sink machine gun regulation very quickly. As applied to machine guns alleged to be in possession after May 19, 1986, prosecutions may no longer proceed under 26 U.S.C. Section 5861. This is because the National Firearms Act is part of the Internal Revenue Code, and its provisions, including registration of machine guns possessed after May 19, 1986, are valid only to the extent that they aid in the collection of tax revenue. Since BATF would not register and accept tax payments for any machine gun after May 19, 1986, registration of machine guns made and possessed after that date no longer serves any revenue purpose, and such registration requirements are invalid. Since 18 U.S.C. 922.0 is interpreted to ban registration and taxation of machine guns under the National Firearms Act, Section 922.0 effectively repeals such registration and taxation provisions. Congress has no enumerated power to require registration of firearms. However, since registration of firearms may assist in the collection of revenue, Congress passed the National Firearms Act in 1934 pursuant to its power to tax. Section 922.0 destroys the constitutional basis of registration. The U.S. Attorney did not appeal that decision, likely afraid it would become precedent for the whole circuit. Interesting argument. I don't know that it really holds weight, but I don't know. I'm not a lawyer, but I find that kind of fascinating. That, the logic being that since they can't tax it, since they refuse to tax it, then they don't have the power to regulate it because their regulations stem from their authority to tax. Interesting argument. Has anybody heard about this one before?
No, can't say I've heard that argument.
I said, haven't heard that one before, but certainly, like to hear the results.
I will chuck the link out there in the chat for those who might wish to try to track this down. There you go, folks. Links out there in the chat. If you want to go to that blog and then follow the links that he has and go down that rabbit hole, go right ahead. And if you don't, hey, don't. It's all good to me. But it sounds like an interesting argument to me, and that's why I figured I would put that in here at the end of the main portion of the show. Let me see. Where am I going next? Oh, yeah. So as we've seen, I like to have a little bit of something interesting and a little lighthearted, and maybe just a little bit hopeful to sandwich in between all the stupidity that we have on this show, because the majority of it's just filled with stupid people doing stupid things. And speaking of stupid people doing stupid things...
And now prepare yourself for another tale of stupidity in this episode of Moron of the Week.
Somebody brought it up before. I think I did watch too much Pigs in Space when I was a kid. You can tell I watched the Muppet Show. This is from the Houston Chronicle. Man arrested after threatening ex-girlfriend with gun, shooting himself instead, police allege. This is from April 28, 2020. A man has been arrested after accidentally shooting himself in the process of threatening his ex-girlfriend with a gun, according to Precinct 4 Constable Mark Herman. Deputies with Constable Mark Herman's office responded to the 1500 block of Daisy Bell Lane on Friday, April 24th, in reference to a weapons disturbance call. When deputies arrived on the scene, a woman told them her ex-boyfriend threatened her with a gun if she talked to any other men. He has been identified as Rashad Clark. Clark then accidentally fired a bullet into his foot as he was putting the gun back into his waistband, police said. He then left the scene and went to a local hospital. Constable deputies located him at the hospital and he was taken into custody after being treated for his injury. Clark is charged with aggravated assault with a deadly weapon. He was booked into the Harris County Jail. His bond and court information have not been set at this time. My only regret in this is that he didn't remove himself from the gene pool by shooting himself someplace else. I think that would have been a wee bit better. Oh my God, Midnight Range says, when are they going to get Marissa Tomei to try a case for the 2A? She was awesome in that documentary I saw. Got Daniel LaRusso and that other dude off. Okay, dude. Midnight. Hats off to you, brother, on that one. That was funny.
Yeah, but the problem is she dumped Joe Pesci and then went and was dating some wrestler and was working at a strip club, so I don't know how that would work at this point.
Well, remember, her biological clock was ticking, ticking, ticking. Next up, this is from the momatarms.com. Let's see, by William Shanahan from 2 days ago. Moms Demand Action's founder actually believes prohibition was good. And I'm not going to read the whole thing. I'm going to go to the salient parts. Just when you thought you've seen, heard it all, out comes Shannon Watts with an example of what she thinks women should aspire to be. From page 19 in Fight Like a Mother, her book. Where are you at? So you may not see yourself as an agent of change, yet, after all, you're probably plenty busy taking care of your kids and making a living. You might think you don't have the time, energy, or guts to be an activist. Well, I have 2 words for you, and I say them with love. Stop that! You have so much potential to affect change, more than you know. Blah, she talked to Nancy Pelosi. Well, that's good. Go ahead and talk to Pelosi. Here we go. The power of mothers to affect change is not a new phenomenon. Women have been the secret sauce in the progress we've made on many social issues throughout history. Just look at prohibition. In the 1800s, chronic drinking in the United States had contributed to so many social problems, including the abuse of women and children. Eventually, women began to organize, which gave rise to the Women's Christian Temperance Union. Because sobriety was considered a Christian value, women, then the religious standard-bearers of American families, were allowed to be on the front lines of the war to eradicate alcohol. Women never looked back and continued fighting political battles in America to end the child labor, expand voting rights and civil rights, stop drunk driving, all the way up to exposing the water crisis in Flint, Michigan. It's almost always women who are leading the charge for social change, and gun violence prevention is no different. Yeah. So, okay, history lesson. Shannon obviously failed middle school history class. Shannon's saying that the women of the Women's Christian Temperance Union should be looked up to as heroes. Before we go into that, the screenshot from the link in the last sentence should give you a taste of what their greatest accomplishment, at least their most famous. Let's see. This is something by History.com's editors about the Women's Christian Temperance Union. Again, Shannon's own quote is saying they should be looked up for what they achieved. Let the propaganda roll, and here's some actual posters of the early 20th century in support of prohibition. Help me to keep him pure. Please vote against the sale of liquors. Shows a mother holding her kid. The Saloon or the Boys and Girls has a boy and a girl standing side by side holding a flag. It's the real issue. Then the nation decreed national prohibition for their sakes, in a picture of a bunch of kids with Uncle Sam looking on. Close the saloons if you believe that the traffic in alcohol does more harm than good. Help stop it. And will you back me or back the booze? Vote yes for prohibition, from the Ohio Dry Federation. It's a picture of a doughboy, a soldier. Safeguard the babies. Parents drinking weakens children's vitality. See a familiar theme? It's for the children. If you don't support prohibition, you're not patriotic. The advocacy and constant badgering lobbying to lawmakers eventually led to the 18th Amendment, which, as we all know, prohibited alcohol. And that worked out so well, didn't it, guys? Yep, they got what they wanted. Booze in the U.S. was outlawed on 1/16/1920. The feel-good advocacy enshrined them and their work in the history books as women who brought change and progress to the United States of America. But at what cost? Thanks to these activists, the term organized crime didn't really exist in the United States before Prohibition. Criminal gangs had run amok in American cities since the late 19th century, but they were mostly bands of street thugs running small-time extortion and loan sharking rackets in predominantly ethnic Italian, Jewish, Irish, and Polish neighborhoods. In fact, the passing of the 18th Amendment in 1919 and the nationwide ban that went into effect in January 1920 on the sale or importation of intoxicating liquor, it wasn't the mobsters who ran the most organized criminal schemes in America, but corrupt political bosses, explains Howard Abdinsky, a criminal justice professor at St. John's University. Then it goes on to talk about Al Capone, Bugsy Moran, Machine Gun Kelly, etc., all the unintended consequences of Prohibition. So for Shannon in the Moms Demand Attention to say that we should look to the ladies who gave us Prohibition as a stalwart example of what can be achieved, yeah, maybe we should look to them as a stalwart example of what can be achieved and the horrible unintended consequences of it. And that gets her a spot on this week's contest for Moron of the Week. So, let's see. Well,
did you see the latest update on Fishbowl Cleaner Lady?
No.
The police in Mesa City, Arizona have officially opened up a murder investigation.
On who?
The woman whose husband drank the fishbowl cleaner.
Oh, yeah?
And died. Yep.
Good. Sean Callahan says, ever notice that you get the opposite outcome of whatever you're trying to fix when Democrats do anything? Actually, he said demon rats. But, yeah. Yes, Warsaw, I've checked out your custom signs you're giving away. They're pretty doggone awesome. You guys, everybody should go over to his channel and check that out and get into that giveaway. But back to the matter at hand. So there we have it. We have our contestants for Moron of the Week lined up. First is the threatening thug. He threatened his girlfriend and ended up shooting himself in the foot. Then we have the malevolent mom, Shannon Watts, for her stupidity in thinking that the Prohibition women were a good thing. And then we have Joe Biden, just for being Joe Biden. So, Squib, who's our moron this week?
Biden.
Joe Biden. Rich, who do you vote for? Who is the dumbest of the three?
Anybody who carries Mexican carry and then shoots himself in the foot gets my vote, especially after threatening their girlfriend with the gun.
Threatening thug. Gunpowder Beauty, which one?
I'm going to have to go with Rich. Anybody that shoots themselves in the foot deserves Moron of the Week.
Threatening thug. Pickle, who do we got? Threatening thug, malevolent mom, or Joe Biden?
Make that a trio with Gunpowder Rich and I.
Threatening thug. Now, here's the part, folks, out there in the chat, where it comes to you. There's 19 of you watching. Let's get some votes out here. Go ahead and tell me who you think should be the moron of the week. Let's see. We got shot in the foot guy, the threatening thug. Anybody else? Come on. Tell me who you think is the worst of the three. And no, people, Pickle's not on the ballot this time. We're not doing right-ins.
Dang it.
La 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 la. Threatening thug from Seven Wonders. Shot in the
When you
foot
do
for
the
gun-loving
law thing,
grandpa.
it sounded like
Midnight Range
you
is
sound
trying
like
to
you're
vote in
about the
DM
Smurf
Foss.
scene there.
What's that, Pickle?
The way that you were singing the La La things, you sounded like what Smurf there for a second.
I am pretty smurfy. So far, we got 6 for threatening thug, 1 for Joe Biden, and none for malevolent mom. Anybody else? 22 of you watching. We got 6. We only got 7 votes. Come on, folks. Give me some input here, man. Give me some engagement. I see you out there. Oh, nope. Someone left. Someone said, engagement? Here, engage this. Click.
Yeah, that's where, those, videos of all the sad-looking animals that they always say, think of Budget as one of those animals. Come on, give them some support.
Yeah, right. Okay, well, I'm going to go. DM Foss says Biden. So Joe, Uncle Touchy has 2 votes. Buck says put them all in one pile. Just Droopin says shot in foot guy. I think that by a landslide, Joe Biden loses to threatening thug. And, just like it's going to happen in November, right?
Actually, what happened is Corn Pop just got his revenge.
David Ramirez says no toes guy. So, yep. Here, I'm going to call it 8 for threatening thug, 2 for Joe Biden, none for prohibition chick. So there we go. Threatening thug. I ain't going to bother looking your damn name up. You're the moron of the week.
And there we had another tale of stupidity in this week's episode of
Moron of the Week.
I really like that segment. I really do. I think it's fun. I have a lot of fun doing it. It is great. I just wish we get more voting. Now I know how the politicians feel. Nobody shows up for voter turnout, right? Got low voter turnout, and people think it's rigged. Maybe that's why they don't turn out and vote. They think it's rigged. They figure it's a one-man, one-vote system, and I'm the one man with the one vote. I don't know. But speaking of favorite segments, we're going to go ahead and move into the final segment of the show, the Self-Defense Shoutouts. For those of you who are new to the show or who have never stuck around to the end, Self-Defense Shoutouts are not where I am reveling in the proposition that the bad guy won the dirt temperature challenge by the room temperature challenge by taking a dirt nap. One of these days I'll say that, without fudging it up. Not where I am reveling in the proposition that the bad guy won the room temperature challenge by taking a dirt nap. It's where I revel in the proposition that the good guy had the means, method, and opportunity to prevent the bad guy from making him do the same. Maybe I should just record an intro for that and be done with it. I think I'm going to have to. I keep screwing it up. Anyhow,
it wouldn't be right of the people without a few mistakes.
I know, man, but I'm trying not to be amateur hour up in here. Come on. Anyhow, this is a piece from 8newsnow.com. Update. Baldwin Motorsports president kills man in self-defense. This is from April 25th, 2020 by Lucas Wright. Las Vegas, KLAS. We now have more information about a deadly shooting from earlier this week. According to a press release from Baldwin Motorsports Las Vegas, their president, B.J. Baldwin, shot and killed a man in self-defense. The shooting happened near the In-N-Out Burger at Tropicana and Fort Apache. According to the release from Baldwin Motorsports, Baldwin had just finished a late-night dinner in the parking lot with his girlfriend around 2 a.m. on Wednesday. That's when 2 men came up to them. One of them had a gun and started shooting. As Baldwin and his girlfriend took cover, Baldwin returned fire, hitting the suspect. Baldwin has a valid concealed weapons permit. The other man then ran away. Police say Baldwin and his girlfriend left the scene, then called police to report the shooting. Police say a woman who had a relationship with the deceased man came to the scene and took his gun. In the Baldwin Motorsports press release, the company says Metro has called the shooting a justifiable homicide. Baldwin has and is continuing to cooperate with Metro Police. Good for you, Mr. Baldwin. Good for you. That's how it's supposed to work. And we only have 2 self-defense shout-outs this week because, well, we're running kind of short, right? It's Wednesday, not Friday. This is from the Chicago Sun-Times by the Sun-Times Wire from today, April 29, 2020. Brothers shoot suspected robber in Bridgeview. A store clerk and his brother shot a suspected robber Tuesday in Bridgeview after he allegedly tried to rob a business in Southwest Suburban Justice for the second time in 5 days. The male tried to rob the store about 6:15 p.m. near 82nd Street and Roberts Road in Justice, but was foiled by the clerk, according to Bridgeview spokesman Ray Hanania. He was also suspected of robbing the same place on Friday. The clerk called his brother, who was driving with friends nearby on Roberts Road, Hanania said. Together, they chased the suspected robber into Bridgeview, where they engaged in a brief shootout. The suspected robber was shot in the back and hospitalized in good condition, Hanania said. Weapons were recovered from both the suspect and the brothers. Bridgeview police are investigating the shootings, while Justice police are investigating the robberies, Hanania said. Charges are pending against the suspected robber, Hanania said. The brothers will not be charged. I am actually really shocked at that since they went chasing the guy and shot him in the back. Of course, you don't know how that happened. But, yeah, I'm really kind of surprised that they're not getting charged with something for that. So, good for them, right?
Yeah, it's like the guy in Texas that chased the church shooter down. They didn't charge him either. So, same kind of situation.
Yeah. Yeah. Of course, that being Texas, that doesn't shock me that he didn't get charged.
This is true.
Yes and no, same situation. That's where correct me if I'm wrong. I didn't hear where the one in this new case fired first and then they chased him. Or did I just miss that part?
Well, he did.
Yeah, they don't say who fired first, and maybe that's it. Maybe they chased him down to try to get him for police or whatnot, or tell the police where he was or whatever, and then that dude shot at them and they had to shoot back. Maybe that's what happened.
Right, because the Texas shooter, they pursued, but the guy had already shot multiple people.
Yeah.
So that, to me, would be the only difference I could see between those.
Yeah, the guy may have been an armed robbery too. If he had the gun, he may have used it to threaten the cashier as well.
Yeah, but hey, the good guys are going free on this and not in the hospital, so I guess that counts as a win in my book, right? Speaking of wins in my book, we're going to go ahead and wrap this up. Want to say thank you to all the panelists who decided to stop in and spend this time with us this evening. Squib, is there anything you'd like to leave us with? Any plugs you'd like to make? Anything you'd like to say?
Nah, I did some plugs last night. Thanks for the invite. Everybody have a good night, good week. Good luck turkey hunting, Budget.
Oh, thank you. Rich.
Sunday nights over on the Unlimited Media channel. Be sure to check out This Week Unloaded. Start time between 8 and 9 p.m. Eastern. And thanks for the invite.
Hey, no problem. Gunpowder Beauty. Is there anything you'd like to leave us with? Where can we find you? And, put your plugs in there.
People know where to find me. Thank you for the invite.
Now, someone might not know. We got some new people out here. Tell them.
You can find me on YouTube, Instagram, and Twitter at Gunpowder Beauty.
See? Go check her stuff
and
out.
My mom did just yell, "Good luck with the turkey hunting," and she is impressed that you were able to call turkeys. You sound just like a turkey.
Oh, thanks. Yeah, well, she ain't hearing me use a mouth call. That's no. Box call?
That's good. Tricky.
What's that?
I said, yeah, the mouth call is a little tricky.
Oh, yeah. Yes, they are. I'm getting there. I think maybe by fall I'll have it down and be able to use a mouth call in the fall turkey season. But, yeah, in the spring it's going to be the slate and the box call mostly. Pickle, Calaveras 32 special. Is there anything you'd like to say? Any words of wisdom, final thoughts, plugs you'd like to make? Anything?
Well, anyone that knows me knows there's not going to be any wisdom, but I do appreciate the invite there, Budget.
Hey, no problem. Seven Wonders does have a question. He says, where can we find Tardot? That's the question. Is he still
I'm sorry,
chained
who?
up?
Handcuffed in the basement.
I don't know of this Tardot that you speak of.
There you go. She denies everything. Mm-hmm. Is this?
Sounds like you might find him. Sounds like you might find him in the doghouse.
Is Tardot going to turn into the next Don Lewis? Going to have night?
I'm sorry, what's that?
Huh?
I said, I'm sorry, what's that?
So is Tardot going to turn into the next Don Lewis?
I don't know. We'll have to see when he gets back from Michigan.
We'll have roll call. What'd you do with Dot? What'd you do with Tardot now?
Yeah, that'd be great.
You fed him to the taggers. I was not going to watch that show. I was going to absolutely refuse to watch it. But I got bored. And then it just sucked me in like a black hole of wretched white trash mullet gravity. It was just, I had to watch all that. I couldn't help it.
I have not watched a single episode of that show.
Stay away, man. Stay away. It is a train wreck. It is a compelling train wreck, but it is a train wreck.
I pretty much got the gist of what happens from everybody else talking about it at this point.
It's wow. That's all I can say is wow. All right. Speaking of wow, I can't believe there are 24 of you still out there watching this garbage right at this point. Thank you so much. As always, I am humbled and amazed that you've chosen to spend this time with us. We started this how long ago? 77 minutes ago, according to YouTube. And there are some of you that are still here from the beginning. Wow. That's why I do this, is for you guys. That's the payoff, is knowing that, hey, there's people out there that actually like this, and I am humbled and amazed that instead of doing absolutely anything else that you could be doing on a Wednesday evening, you're listening to this. Thank you so much. As we have seen in the topics that we talked about tonight, we need to let our elected representatives know that we're not going to tolerate their attempts to infringe upon our divinely given rights. Send them a snail mail, email, telephone, telegraph, carrier pigeon, smoke signals, bicycle messenger, semaphore, heliograph, anything that you have to do to let them know what you think, and never, ever, ever give up the fight. And I'll see you guys next week.